Mr Hodge. Old habits die very hard. I say 11:40, I come back at 11:40. I should get out of those old habits, I suspect.
We're all here, Commissioner.
Yes, Mr Hodge.
Commissioner, the first witness is Mr Khoury.
Thank you. Mr Khoury, would you prefer to take an oath or make an affirmation?
An affirmation, please.
Do you mind standing then, please, Mr Khoury?
I solemnly and sincerely
I solemnly and sincerely
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Do sit down. Yes, Mr Hodge.
Thank you, Commissioner. Your name is Philip George Khoury,
Correct.
and you've provided your address to the Commission,
I have.
and you've received a summons to give evidence today.
I have.
You have that with you?
I do.
Commissioner, I tender the summons.
Exhibit 3.3 will be summons to Mr Khoury.
Mr Khoury, you've prepared a witness statement for the Commission,
I have.
and the relevant witness statement, I'll come to this in a moment, is one dated the 18th of May 2018.
Yes.
And again, you've got that, a copy of that here with
I
you
do.
today. Commissioner, I tender Mr Khoury's witness statement dated the 18th of May 2018.
Exhibit 3.4, witness statement, Khoury, 18 May 18, and its exhibits.
Mr Khoury, you're a principal of Cameron Ralph Khoury.
Yes.
And, sorry, could you just because it's being recorded, could you speak
Sure.
up a little bit? Thank you,
Yeah.
Mr Khoury. And can you tell the Commission what services your firm provides?
We provide governance services, so governance advice, design of governance systems, board evaluations, director evaluations, and also advice in the space of loosely called self-regulatory activity, complaints handling, external disputes resolution, codes of conduct, etc.
And your firm has conducted a number of independent reviews of financial sector external dispute resolution bodies,
Yes.
and not just in Australia but also overseas.
Also overseas, Canada and New Zealand.
And what is your background, Mr Khoury?
Relevant to this, my background is I worked for the Australian Securities Commission and the Securities and Investments Commission for around 9 years.
I see. And how long have you been a principal of Cameron Ralph Khoury?
Since 2002.
Thank you. And you were commissioned to carry out a review of the Code of Banking Practice.
I was.
And I mentioned earlier that the correct statement is dated the 18th of May 2018. We surprised you a little bit on Friday of last week by giving you a new draft of the code.
Yeah.
And so what you've been provided with is the most recent draft of the code that we have that's presently under consideration by ASIC. And you've had a look at that.
I have had a look at that, yeah.
And I think you've updated some of your views based on what's been your review of the new code, or the further version of the code. Is that right?
Yes, that's right.
Okay. Now, what I wanted to do was to just talk through, to begin with, the process that you went through in reviewing the code as it was in 2016. It was back then, about the middle of 2016, that the then named Australian Bankers Association approached you to review the code.
Yes, that's right.
And at that stage, the current version of the code was the 2013 code.
Yep, that's right.
And your engagement was publicly announced at the beginning of July 2016.
That's right, the 7th, I think.
And ultimately, your finalised report was delivered on the, I think you say substantially finalised on the 31st of January 2017.
Correct, yeah.
There'd been a short extension given, had there, to produce the report?
Yes, we had promised to do our best to make it December 31st, which we couldn't make in the end, and asked for an additional month to complete the report.
And in terms of the approach that you took to reviewing the code, was there an initial process that you had in mind, what you would try to do?
Look, we, having worked with the disputes resolution schemes extensively, we're familiar with some of the points of contention around consumer protection in the space, and we had hoped to use as much evidence as possible to settle some of those arguments. So we had hoped to get data from the banks and from other sources that would help to provide us with evidence-based resolution of some of the contentious issues. As it turned out, that data didn't end up working out to help us as much as we would have hoped. So within a couple of months, it was evident that we would need to use a bit of a different approach.
And what was the different approach that you adopted?
We had originally been asked to review the code from the perspective of what stakeholders wanted from banks and what would help restore trust in the banking industry. And in the absence of compelling, precise data on a lot of the issues, we just retreated back to that logical equation. What are stakeholders asking for? What would be reasonable for the banks to offer, you know, on our recommendation?
I see. And I think you say in your statement that there was an emphasis placed on the importance of, or a particular way in which the code needed to be approached in order to achieve that trust or the rebuilding of trust. Could you just explain that to the Commissioner?
My, I suppose, initial criticisms of the existing code at the time were that it was really written from the point of view of the banks very much, and the language wasn't accessible for consumers. It wasn't accessible for small business. It wasn't clear in many cases really what the promise was. And we took the code to be a document that was a promise from the industry to its customers, and that the language should really be much more framed in terms of those what customers should expect from the banks.
And could you explain the idea that you explained about paragraph 6 of your statement, that changes or the recommendations would need to be significant or transformational to overcome scepticism?
In our very initial conversations with stakeholders as we began the process, a number of people put to us that, and they subsequently echoed this in their written submissions, that there would have to be quite a leap in terms of the code's framing and the code's provisions for it to impact on their trust in the banks. That if at the time the messages on the ABA website were "we are listening and we are improving," and people quoted those directly to us and said this will have to be transformational in nature to have that impact that the ABA are looking for.
And that was another thing then that you were taking in mind in assessing what recommendations you ought to make?
Indeed.
All right. Now, what I want to do then is work through a few particular issues in relation to small businesses and the way in which the code deals with small businesses. The first is the definition of what is a small business. And in your statement, you refer to that as a threshold issue. Again, you just need to say,
Yes. Yeah.
And can you just tell the Commissioner what that threshold issue is?
Look, the law doesn't really provide a huge number of protections for small businesses in their dealing with banks, in lending and so forth. So the code is quite an important vehicle for protection for small business. It already in 2013 extended some protections to small business they wouldn't otherwise have received. And so the question of who is a small business and who would be caught by the code becomes pretty important as a starting position. In other countries, there are quite different definitions of what is a small business. They more frequently distinguish between a micro enterprise and small to medium enterprise and so on. So we had already encountered a number of arguments that would would argue to exclude businesses on the basis of their scale or complexity or sophistication. So we thought it was pretty important to just get clear about who we are talking about in the first place.
And did the member banks have a particular approach to the definition of small business that they presented to you?
There were a couple of things going on at the time which I think have affected the position that the banks put to us. The 2013 code had nothing more than an employment test in terms of whether someone was to be treated as a small business. There were practical issues outside of the code which go to, which you mentioned earlier, FOS's jurisdiction or the CIO's jurisdiction. And so I think these were influencing the way the banks responded to it. But we had previously come to a view that the cap on whether a business qualified as a small business under the code, and also when they went to an external dispute resolution service, could certainly be higher than it was cast at the time. We accepted the argument that the banks put to us that at some point, as you go up the scale of a small business, you no longer use standard form contracts, the businesses are more sophisticated, the terms of the credit may be more complex, and so on. And so there is a point at which what's appropriate to a small business should stop. And the normal provisions in the law apply. We just thought that should be higher. And so when we put, quite early in the piece, put the proposition of a $5 million cap on the on qualifying as a small business, the industry came back with a new proposal for defining small business fairly early in the piece.
And I just want to just break that down a little bit. When you talk about a $5 million cap, you mean a $5 million cap on the value of a facility that would be covered by the code, is that right?
That's correct. Yep.
Okay. As opposed to a cap on annual revenue or anything like that?
Yeah, or a cap. As it turned out, the industry's proposition was to retain the employment test. This is during the review, retain the employment test to put a cap of a total of $3 million of credit exposure for a company and a $10 million turnover test as well. So the industry at that point were, I think, pretty keen to rein in the definition of small business.
And did you have any discussion or receive any submissions from the Australian Small Business and Family Enterprise Ombudsman about the definition?
Indeed, the Small Business Ombudsman put a submission to our review, making one point, which was the employment test should be 100 employees without any complication over manufacturing and so on, which would line up with the Small Business Ombudsman's jurisdiction.
And what about the value of facilities to be covered?
That wasn't part of the test, from her submission at any rate. Yeah.
I understand. And in terms of the view that you took about $5 million, can you, we know obviously ultimately your recommendation was that it'd be $5 million. Could you just explain to the Commissioner how you arrived at $5 million?
Well, I have to say we had sort of come to that view much earlier. We did the independent review of the Financial Ombudsman Service in 2013, and the issue arose then about the Ombudsman's jurisdiction, and we had interviewed a number of people in the industry, in the Ombudsman Service, consumer advocates and so on, around the where the limit ought to be, and had examined a number of case files as part of our review, and had come to the view that it could certainly be much higher, and we thought $5 million was reasonable at that time, made a recommendation to that effect for the FOS independent review. And we found in the course of the banking review that, well, we agreed with ourselves really. We didn't find anything that caused us to think differently about that.
And I should just clarify, when you say we, you had somebody who was assisting you with carrying out the review, is that right?
I did, yeah.
Okay. And when you say we, you mean you were the leader, but you and the person assisting you?
My colleagues, yeah.
That's right. And I just want to understand one point, which is about that sort of casting the line at $5 million and your review of the case files. Did they tell you anything about the complexity of loans, or did you form any judgment about the complexity of loans above and below that threshold?
Look, that's a difficult thing to do with any certainty. Our feeling, having looked at them, was that there's certainly great variation in terms of the loans on either side of that line, but most of the loans below 5 we felt were pretty really aimed at the unsophisticated small business, which we thought was the purpose of the code. Once you got over 5 million, a significant number of the loans were more complex than that and really aimed at a different market, we thought. So.
And during the course of your consultations, presumably you put to the member banks this idea of a $5 million limit?
Yes, definitely. Yeah.
And what was the response to that $5 million limit?
Industry indicated they weren't happy with it. They thought it was too high, and indicated to us that they had come up with a different way of framing it that had the multiple tests in it as described before. So test for total exposure, test for turnover, and a test for employment.
And we'll come to some of the other tests in a moment, but just in relation to choosing between $5 million or $3 million, what was the rationale as you understood it? Obviously you ultimately didn't accept it, but what was the rationale for bringing it lower down to $3 million?
Look, we understood the bank's position was really based around their current practices. So we heard evidence that they structure internally different divisions or sections of the bank largely on the strength of the amount of money involved. And so some banks would have an upper limit of $1 million and loans would be dealt with by a different area other than the retail section, others 3 million and so on. So we got the impression that a big factor for the banks was just the internal organisation and how they manage their own compliance and risk management internally. I think the banks said to us that they felt that loans became more complex above that $3 million. And I think they also, another argument put to us was that if the provisions for protection of small business increased banks' risk, that they would, the availability of loans would reduce and potentially the cost would increase if those protections were too onerous.
I see. But in the end, having considered those various arguments, that wasn't the view that you took?
No, we didn't take that view. It doesn't take very long looking at examples of small business loan files to see that the zeros can come on quite quickly without changing whether a small business is a sophisticated operation or not.
That is, a loan for $50,000 versus a loan for $500,000 versus a loan for $5 million.
Indeed, that there were many that were really targeted at the classic small business, unsophisticated operator, but there's significant amounts of money involved.
And now then the other thing that you referred to is this idea of extra tests in relation to what qualifies as a small business loan. I may have misunderstood this, but your initial instinct, would it have been limited to the monetary cap without any other qualifications on what constituted a small business?
Look, we thought, we agreed with the Small Business Ombudsman's proposition that a simpler employment test would make it easier for small business to know whether they were in or out. So we began from that point. The $5 million was really, we proposed it as a protection for the banks because there's no upper limit in the 2013 code. So that was a protection for banks to say once it got beyond 5, these provisions would evaporate, would no longer apply. And the banks also put to us that there could be gaming of the limit with 100 employees, and corporate groups could put their divide their employees up into groups of 99, for example, in order to gain protections that they ought not gain. So we put in an additional qualifier as protection for the banks to simply say that if it was a corporate group, then the total number of employees within the group would be what you would count.
Right. Now, you've seen two different drafts of the code that was submitted to ASIC. I think when you prepared an original statement, you'd only seen the draft that was submitted in December of 2017.
Yes.
And then, as I say, last week we provided you with the more recent version from April of 2018.
Correct. Yep.
And you've looked at, perhaps we might just bring this up. Can we bring up tab 3 of Mr. Khoury's, the exhibits to Mr. Khoury's statement? Should be exhibit PGK-3. Do you want a document ID? It's WIT.0900.0003.0290. And if we go to page 5 of the document, I'm sorry, numeral 5 rather than Roman number 5. It's .0299. Thank you. We can see here the definition of what is a small business, and the tracking indicates the change between December 2017 and April 2018.
Yes.
And so in part, there's been a movement since December 2017 to reflect your recommendation that the employment test just be 100 full-time equivalent employees.
Yes, correct.
And I want to ask you then about the other two elements of the test. The first is element C, which is the $5 million limit. That's obviously less than the $3 million limit. That's less than the $5 million limit that you recommended.
Well, it's less in two ways. Firstly, a smaller number, but secondly, that it is intended to take into account all the loan exposures of the small business rather than the facility that's in question.
And all loan exposures not only to the particular credit provider, but to any credit provider.
Indeed, yeah. So it's significantly different to what we recommended.
Yes, significantly different to the recommendation that you had made, which is that the monetary limit is $5 million for the particular facility. Is that right?
Correct.
Okay. And then there's also subparagraph A, an annual turnover limit that is not something that you'd recommended?
Correct, yeah.
And do you have a view about the incorporation of this annual turnover limit?
Look, I think it complicates the definition. In various times over the last few years, in a number of arguments been put to us that the turnover test is too onerous for banks to administer. Clearly, that's not the case in other countries. A turnover test is not uncommon. But we had not recommended it because we thought it was just unnecessarily complicated and sort of there are practical issues about that for someone like the Financial Ombudsman Service, for example, or AFCA now, of having to decide what the turnover is and obtain evidence about the turnover through tax returns or some other means, making the process of figuring out whether a small business is in or out lengthier and more complicated.
And to figure it out as at the time they were borrowing the money in the first place.
Yeah, indeed.
And that criticism of complexity then, does that also apply with respect to this $3 million in total debt to all credit providers?
Look, I think so. And I think it could if you go back to the original premise that the code is a promise from the banking industry to its customers in plain-speaking language that will engender trust, my recommendation is that you would say it more simply than that.
And I think in your statement, you were contemplating a slightly simpler question, which is what would happen if you just moved from $3 million for the facility up to $5 million for as a facility limit, and what the effect on that would be. This is at paragraph 17 of your statement.
17 of my statement. Sorry, I'm going to need to refresh my memory on that.
That's right. Oh, I'm sorry, it's now moved to be paragraph 18 of your 18 May statement.
Oh, yes.
So I think you explained two things there. The first is that your proposed definition was something that you thought would have a relatively small effect, extending coverage to an additional 10,000 to 20,000 businesses. Mm-hmm. And secondly, that you took the view that the comparatively minor concessions to fairness that the code represents would not substantially alter the balance of power between a $900 billion bank and a business with a few $1 million of financing. Could you just explain to the Commissioner what you meant by comparatively minor concessions to fairness?
Look, most of the concessions that the code talks about are providing notice, providing information, providing access to external dispute resolution. These are things that our assessment of community expectations is simply around fairness. It's not tilting the balance of power dangerously away from the banks, so that we didn't think the concessions were so enormous that the argument that this would be grossly unfair to banks was particularly compelling. In terms of our estimate for how many additional businesses it would cover, that's quite a difficult thing to do, as no doubt you've noticed looking at the statistics, but on the information that the banks gave us at the time, that was our guess about how many additional businesses would be scooped up by that change.
And did the banks suggest to you that it would be a significant number of businesses that would be affected if they moved from 3 million to 5 million?
Look, that wasn't a bone of contention, so the information was provided to us. The banks had a chance to review what we had said in the report and didn't take exception to it.
And is that 10 to 20,000 businesses, is that based on the simple premise of a facility limit of $3 million versus a facility limit of $5 million as...
It was 5. Our estimate was, looking at the stats that we could find, was that about that many extra businesses would be scooped up if you made it a $5 million facility. Now, we did not, that was at the stage of thinking about it in terms of a simple test for the facility rather than the more complicated test that's been put forward.
Yeah, and the particular part of the more complicated test that you're referring to, I'm assuming, is the $3 million in total debt from all credit providers, which would be
the turnover question, which again we couldn't find any useful statistics to help us with that at the time.
Thank you. I want to move then to the second topic that I want to explore with you, which is your consideration of responsible lending to small businesses. And the code, at the time you were reviewing it, the 2013 code, contained an obligation in clause 27 on a signatory bank to exercise the care and skill of a diligent and prudent banker in selecting and applying credit assessment methods and forming an opinion about the ability to repay the credit facility.
Yes.
And as you note in your statement, that's not the same as the responsible lending provisions provided in the National Consumer Credit Protection Act.
Correct, yeah.
And those provisions in the National Consumer and Credit Protection Act don't apply to a loan entered into for a business purpose.
Correct, yeah.
And you explain in your statement that one of the things that you considered as part of the review was whether clause 27 struck the right balance between, on the one hand, access to credit, and on the other hand, responsible lending.
Yes.
And can you just help us, or help the Commissioner to understand what were the views that were coming from small business representatives to you about that?
This was a very important issue for them. The access to credit is certainly priority number one put to us by the representatives of small business that we spoke to. And while they were also interested in some protections for business, they in particular did not want to import an onerous responsible lending obligation that would cause access to credit to dry up. So there was a big issue about whether that was the correct balance or not. And we were urged by most of those representatives to not to overdo recommendations in terms of responsible lending.
That is, most of the small business representatives not
Yes.
to overdo it.
Yeah.
All right. And what was the view that was expressed to you by banks about that?
Look, I think the banks were in furious agreement with the small business reps on that front. We put to them some issues about accessibility and understanding from small business and so on. But I think they had the same view, that their preference was that whatever protections were put in place would not materially change the access to credit for small business.
And there was a submission made to you by CPA Australia in relation to lending. Could you just explain that submission to the Commissioner?
Look, I think the CPA also thought that that was a critical issue for small business, so that they didn't differ from, I'm having to do this from memory, they didn't differ from the rest of the small business submissions put to us in terms of that access to credit. They were much more concerned about the conduct of the loan during its course and if there was a need to vary any conditions, what would happen at the end of the loan, what would be the conditions for rollovers of credit facilities and so on. So that was from my recollection, that was their focus.
And in the end then, what was the view and recommendation that you formed about responsible lending?
Look, our view was that firstly it was quite inaccessible to talk to most small businesses in terms of what a diligent and prudent banker would do was pretty meaningless as far as we could see. Probably the second biggest issue that small business put to us was the fact that they couldn't understand, they found it incredibly difficult to understand bank procedures, legal terms that banks would use, contract provisions and so on. So a move to some plain speaking in that space was clearly a priority. So we thought you could certainly do something around that, provide them with better assistance. We also thought that there was some risks in the way the code operated at the moment on responsible lending, because it didn't actually spell out the sorts of tests or work that a bank would need to do to be a diligent and prudent banker. So we thought the code could helpfully do that in plain English. And we were also concerned about guarantors. So it was put to us by a number of people, and we were unable to find real evidence for this, that banks were relying too heavily on the presence of a guarantor's assets and not doing sufficient homework on the underlying sustainability of the business loan. And the argument was that the banks were happy because their risk was attended to by a mortgage over someone's house or some other kind of asset, and were not being as diligent as they ought to be around the assessment of the loan, underlying loan itself. So again, we wanted to do some work around the guarantor provisions because we think that's a particular vulnerability.
And we'll come to the guarantor provisions in a moment, but you made general recommendations about what was clause 27 of the code, and can you just explain to the Commissioner what was in terms of the recommendations that you were making, what was the idea, what were the things you were trying to achieve?
Well, so that the clause would be written in a way that small business could understand what the code would offer them in terms of the obligations on the bank when they were framing a loan or making an offer in that space. Some more specific setting out of the work that the bank would do to assess the loan, some provision of information to the small business around what the bank had considered, and if they were refusing a loan, to provide, provide reasons for why the loan was refused.
And that, I should just clarify, that clause 27, as it wasn't limited to small business lending, was it?
No, that's right. I mean, that's been a sort of an issue throughout with which parts of the code are specifically written to for small business and which are not. But I'll have to refresh my memory, I'm afraid, on our recommendation. Do you have the page reference there?
I don't think we've got the 2013.
No, I meant in my report.
That's right. Why don't we deal with this in a different way, which is if we bring up tab 3 of the exhibits to your statement, which is the one we were looking at a moment ago, which is wit.0900.003.0290, and go to page 13 of that document, which is .0307. And so this is part of the new draft code that's currently being considered by ASIC, and you've had a look at this.
Yes.
And perhaps if we start with a general point, this sets out a responsibility in relation to lending not only to small businesses but also to individuals. It's all dealt with under the one section.
Yes. Yeah.
And it appears to impose the care and skill of a diligent and prudent banker test to a number of different, well, both to individuals and also to small businesses.
Yes.
But then it contains a specific provision in clause 51 about assessing appropriate circumstances.
Yes.
And are you able to tell the Commissioner, from your perspective, is this a move towards what you had in mind in your report?
Yes, it at least sort of sets out what is expected of the diligent and prudent banker test. Have I got that in the right order? So look, it's a step in the direction we recommended. We would have preferred to see much more specificity in there, sort of setting out more clearly what the bank would do, but that is a step in the right direction.
And you'll see, though, there's an additional part that deals with the resources of third parties.
Yes.
And do you have a view about that?
Yes, we think that's a backward step. That in effect, on our read of it, it provides the banks with clear authority to take into account a range of third-party resources in how they will assess the viability of the loan. In a practical sense, I guess they've been doing that in any event. My suspicion is that that is in there to put beyond doubt their ability to rely on the guarantee. And that's how I read it in any event, I should.
And in terms of based on your consideration and an evaluation of what sort of test might be applied by the diligent and prudent banker, is that something that you expected to continue to form part of the consideration?
Look, I think it should. This is a question of trying to strike the right balance between relying on and being able to bring in a guarantor's assets as a risk management mechanism, but not to the extent of not paying enough attention to the affordability and sustainability of the underlying loan. So, and it's a difficult thing to strike the balance exactly right on. Small businesses will tell you when they start up, there isn't any other way that they can get a loan without having some security that the bank can rely on, because they have no track record, no cash flow records, no tax returns to rely on in terms of viability of the business. So the need for reliance on guarantors' assets is there. This is set out we think it's set out in a way that is really designed to protect the banks.
And I want to just make sure we distinguish between two things. One is the assets of the guarantor, which might be offered up as security. The other is the income of the guarantor, which might be relevant to servicing the loan.
Yes.
And do you have, or did you have any expectation, or have any expectation, as to whether or not the income of the guarantor would be factored into assessing the serviceability of the loan?
We think that's, we argued against that. Our view was that unless there were sort of unusual circumstances, the income shouldn't be taken into account unless the person was actually a co-borrower and getting a benefit from the loan. But again, we accept that it is a difficult area to be entirely precise around in terms of those sort of resources. A guarantor may put up an asset, but in the event that it's called on, may prefer to satisfy the security by some other way, and that might be through their income. They might be able to negotiate a solution like that. So, while we didn't want to, rule out every possible arrangement, we did want to have a code that said we will deal with this in a way that makes it clear where the priority should be in terms of responsible lending.
I want to move now to the topic of, specifically the topic of guarantors. You considered the protection of guarantors under the code?
We did.
And did you hear from any particular groups or public advocacy groups about the problems of parental guarantees?
Very many submitters raised the issue of family guarantors.
And what was the particular issue that was raised with you?
Really, guarantors offering up their guarantee without understanding the risks. In the extreme end, this could be a product of abuse, elder abuse, familial abuse. In fact, even the guidelines that the banks have put together for this alert bank staff to the possibility of coercion in obtaining guarantees for someone else's loan. So this was clearly an issue. It's also, without necessarily crossing over the line into abuse, it's very clear that people were wanting to help family members or associates and getting themselves into a highly risky position that they were not clear about as a result of goodwill.
And one of the things that you considered was whether the signatory banks should be required to, or obliged to do more to have potential guarantors obtain independent legal and financial advice.
Yeah. So we wanted that strengthened, and the code, the new draft code certainly goes a fair way towards strengthening those protection for guarantors. So there's a 3-day cooling off period proposed, better information provided to the guarantors prior to signing up, commitment to providing information to them of any underperformance of the loan during its life, and providing them with some assurance that should the guarantee be sort of called in, or the loan be called in, that the banks would begin with the borrower's assets and rather than going straight to the guarantor's assets. So I'm not sure that's exhaustive, but that was the intention.
And sorry, if we just break down that last point, the issue was that the bank might call on the guarantee and the property that secured the guarantee before it actually called on the assets of the borrower. Was that right?
Correct, yeah.
And there might be practical reasons why the bank wanted to do that, because it might think that the guaranteed property would cover the entire value of the loan.
So sometimes there would be no alternative. The borrower may not be able to be found, for example, or the borrower has no assets or has been made bankrupt. So there's lots of reasons why the bank may need to go to the guarantor's asset or security, but we wanted to make sure that the code set that out as a second resort rather than the first.
And in terms of your view about the new code, do you have a view then as to what extent it picks up those things?
Look, I think it's gone a long way towards those. I mean, there are still some things in there that we would, you know, I would rather were framed, you know, slightly differently, but it does go a long way towards the sort of guarantor protections that we wanted in the code.
One of the things that we were talking about a moment ago is this idea that the banks ought to encourage guarantors to go and seek independent legal and financial advice. And I'm wondering if you have a view of whether there were submissions made to you about what would actually be involved or what is necessarily involved in a guarantor getting proper independent legal advice.
Look, the code sort of sets out a few safeguards in terms of signing the documents not in the presence of the borrower, a few other provisions like that. The problem with the legal and financial advice issue is that at the beginning, when the loan is being contemplated, far too often, particularly if it's a family member, people are unwilling to seek that advice. They would prefer to take the sort of optimistic view that's been put to them by their family members and so on. So I'm told there's quite some resistance to seeking that advice from guarantors. And while they can be encouraged to do it, at this stage there's no compulsion.
I wanted to move then to...
Just before you do that, you spoke of the changes in the code providing for better information being given to potential guarantors before they signed up. Can I understand better than I now do what the changes were? What was the better information that is proposed?
Okay, well, let me just...
Would it help if we brought up the
Sure,
new
yeah,
code?
that would probably
So
help.
if we go to wit.0900.0003.0290, and going to Part 7 of the code, which should be at page .0313. I don't know if it would be helpful, Mr. Khoury, in addressing the Commissioner's question, if you also wanted to refer to the particular part of your report. Would that assist you? I might just
Sure.
know where that is so that we can bring that up as well. If we bring up the document which is Exhibit 1 to Mr. Khoury's statement, wit.0900.0003.0001, and go to page .0112. Perhaps over the page .0113 is the recommendation that you made about information.
So the code, as the code is at the moment, they drafted the, we wanted to spell out the information that had to be provided to the guarantor beforehand, so information about the financial position of the borrower, you know, the terms of the loan, the sort of information that would be provided to the guarantor during the course of the loan. So the code has been, you know, my assessment is that the provisions that are in that Part 7 of the code have gone a long way towards what we recommended. We had one recommendation which the banks were very clearly opposed to, which had come to us from the Financial Ombudsman Service, which did not get picked up in here, and that was the recommendation that the code explicitly say that if the guarantor provisions had not been adhered to, the guarantee could be set aside, that it would no longer apply. And Financial Ombudsman Services' argument for that was, although it, I'll come back to that in a second, the argument was that there needed to be a very serious consequence for the banks in order for them to adhere to the guarantor provisions religiously. The banks were opposed to that. I think didn't take account of causation, and so you could have an environment in which some minor breach of the code guarantor provisions resulted in the entire liability being set aside, which they thought was unfair and would be gamed by some customers. We made the recommendation in any event because we thought it was an issue that deserved to be considered by the banks and put in the domain. So that was the main one that we didn't that didn't appear in the code afterwards. It's the main provision.
Is the guarantor given any information about why the bank is asking for third-party support? The bank's saying to the borrower, I will lend, but only if you give third-party support in the form of a guarantee, either an unsupported guarantee or a supported secured guarantee. Does the guarantor know why the bank is asking for third-party support for the loan?
That's not specifically requested in the drafting of the code as it is now.
Because that bears upon what legal advice can be given. Mm-hmm. The lawyer who is confronted by the would-be guarantor, if it happens, I understand there's a big caveat about if it happens, the would-be guarantor sits there and says, should I not enter this? At least there's an available point of view that question one for the lawyer would be, well, why is the bank looking for third-party support? Unless I know that, how can I tell you whether you should or shouldn't?
Look, I would have to, it's not specifically identified. It wasn't in our recommendation, nor is it in the current code. I think I would have to check. It's possible that other provisions in the code would oblige that information to be provided.
Can I just help you out with that, Mr. Khoury? If we go to page 0314 in the document on the left-hand side of the screen. So this is, you see the heading guarantee documents, and there's clause 99, and it sets out what documents have to be given in relation to the borrower. And you see subparagraph E requires the bank to give to the guarantor any financial accounts or statements of financial position that the borrower has given in the previous 2 years for the purpose of the guaranteed loan. And subparagraph F requires the latest statement of account. But then you see subparagraph G is the other information we have about the guaranteed loan that you reasonably request, but we do not have to give you our internal opinions. Yeah. So that, I'm really just putting this to you, you can agree with it or disagree with it, but certainly as it appears, you hadn't made a recommendation that dealt with the specific nuance of the issue that the Commission has raised. That's the first thing.
Correct.
And the particular piece of information, which is the basis upon which the bank has made its decision that it requires the guarantee, appears to be something that is left at the bank's option as to whether it would have to be required, and only if it was requested.
Indeed. I think that's correct, yep.
Commissioner, did you want to ask any further questions about guarantees?
Yes, but I won't.
Can we move then to the issue of loan contracts and simplification, which is another issue you raised in your review? And do you recall what were the issues that were raised with you by small business representatives about the simplification of loans?
Well, first one is that documents at the time were described as impenetrable and far too difficult to understand the impact of each of the clauses. So I think that was a sort of a first principles issue put to us. The second one, which has been raised with other reviews, is the small businesses' horror at discovering the extent to which banks could unilaterally vary contract terms. And probably another dimension of that was the extent to which small business borrowers were shocked to discover that the extent to which non-monetary clauses could be breached and trigger sort of default action or unilateral variations to the terms of the loan, so increased interest rates or demands for more information, other sort of obligations. So they were probably the main ones put to us about that, and then there was another set that come to bear in terms of the end of the loan, if you like, the sorts of things that might happen at the end of the loan.
Well, if you take the first issue, which is simplification and making them impenetrable, you made a recommendation as to what should be done to try to address that. And could you just explain to the Commissioner what the recommendation was?
At the time, as part of the unfair contract legislation being introduced, the banks assured us that they were redrafting, in consultation with ASIC, they were redrafting their standard small business loan contracts, and that they would come out much simpler and easier to understand, which we took them at their word for. We did add in one recommendation on that, which was to require a short form summary of the key aspects of the loan contract, that would be in one place, and a 1 or 2 page takeaway for the small business person, where the critical dimensions of the loan were set out in simple language for them. So that was one other one around that very first issue of understandability, I suppose.
And we'll bring up the clause in a moment, but just to focus on that issue of understandability, one of the other issues that was raised with you was understanding why finance was refused. Was that right?
Yeah, that's true too. Yeah.
And so if we bring up, again on tab 3, wit.0900.0003.0290, and go to page .0310. And if we blow up first clause 73, that seems to be the implementation of that first recommendation you were talking about having some simple summary.
Yes.
And do you have a view about whether that meets the requirement you're after?
Look, it's a step in the right direction. We were a little bit concerned about the proposition that it'd be a separate document or part of the loan document. I've had no chance to sort of test the intent of the codes clause, and so that may or may not be successful. I'm assuming that the intention there is to allow each bank to have some flexibility about how they implement. So it's a step in the right direction.
And then as to the issue of explaining why finance was refused, that was something you also made a recommendation.
We did.
Yeah. And what was the recommendation that you made?
That, and this was something asked for by the small business advocates, that if a bank refused an application for a loan, they should provide the applicant with enough information for them to understand why it was refused, and without a promise of providing a loan in different circumstances, give the applicant an idea of what would have to be improved in order for the loan to be successful, the application to be successful.
And if we blow up clause 74 of the proposed new code, that seems to be adopting that recommendation.
Yeah, so it's a bit of a sensitivity with the banks about just how much information they'll provide at the end of that process. I take exception to the language probably, but I think it is, yes, adopted.
I'm sorry, when you say you take exception to the language, what do you mean by that, Mr.
Look,
Khoury?
I just don't think that. I think small business reading that would treat it as weasel words, really. If appropriate, general reason why, so on. Well, we did urge the banks to try and be as plain speaking as possible in all of this, and not to guard against, rare occurrences that might be.
A bit hard to require the bank to say, we don't trust you. I mean, at some point, a bank has got to make a judgment about the customer.
Of course.
And there may be cases where that's the real reason.
Indeed. And we understand that would be the case sometimes.
Now, the second issue you raised before in relation to the simplification of terms and the drafting of terms was the issue of unilateral variations. And you made a recommendation about unilateral variations.
We did. Do you have that there?
I can do that, but why don't I just bring up the actual draft code so that we can just have a look at that and you can tell us your view about that. That's in the same document, page .0321. So this is chapter 9 dealing with when we change our arrangements, and as you'll see in clauses 152 and 153, there's provision for changing interest rates. And otherwise then there's separate provisions dealing with what are referred to as unfavourable changes.
Unfavourable changes, yeah. Look, this is an area where I think we didn't do as much as we should have done in this sort of question of unilateral variations. So again, there were changes afoot at the time, but I think as I look back on it now, I think we've probably not done as much as we could have in the area. So we've ended up with a provision that says we'll give you plenty of notice, but we can still unilaterally vary the terms of the contract. And I suspect that's an area where I would like to have had my time over if I'd understood how it would all land.
I understand. And then the last point that you raised then was about enforcement of loans, and I think you were referring specifically to non-monetary defaults. Is that right?
Yeah.
What were the issues that were raised with you by small business people about non-monetary defaults?
Well, aggravation that what they saw as possibly minor variations in the non-monetary terms resulting in quite significantly adverse changes to the terms of the loan. So interest rates being increased, or calling in the loan in an extreme environment, demands for quarterly or monthly extensive financial reporting. Those were the sorts of issues that had been raised with others and were raised with us in terms of the non-monetary default provisions within the contracts. The Small Business Ombudsman, prior to the release of our report, had come out with her recommendation that this be, dramatically scaled back in terms of, whether default action could be taken as a result of non-monetary breaches of the contract terms. And in the end, we made a recommendation that was consistent with hers.
And just explain, what was that recommendation, if you explain
Was that other than illegality, there should be no grounds for defaulting a loan, provided the borrower was continuing to pay meet their payments.
Although, was there a qualification about specialist type
specialist
of lending?
finance, yeah. That's
And just so the Commissioner can understand that might mean, for example, property development finance or something like that?
Yes, yeah.
And I want to then ask you about your view about how the draft code has implemented that. So if we go to page .0311, you'll see clause 80 begins, if you're a small business and you have met all your loan payment terms, we will not take default-based action against you unless, and then there are 12 sub-paragraphs of exceptions.
Yeah.
What's your view about the extent to which this lines up with the recommendation that you'd made?
Look, I suppose I was initially pretty concerned about the way that's framed. I think that's a classic example of the way in which the language and the framing of the code is small business unfriendly, if you like. So that was the sort of first, I don't have a solution for it, of course, yet, but having read that, I think that was my sort of first reaction to it, as this would read badly as a small business customer. And I think the array of provisions there, on my read, and again, I am not a lawyer, but on my read of it, it looks as if there's enormous discretion for the bank to use one or other of those circumstances to justify taking default action.
It is qualified by clause 83, which says it's only if it's material or was reasonably considered to be material that it's to be relied upon. Do you have a view about that?
Look, I think it's a step in the right direction to use the word material, and I think that was a bone of contention from a number of the small business people that we spoke to, was that they, they felt that some of these things were not material and were being used to the bank's advantage.
Thank you.
Unfairly used to the bank's advantage.
And I might just ask you about two further questions. The first is, have you considered, or did you consider, any overseas examples in considering the code?
Look, we did some research on what was available overseas. The three examples that we found most useful were the Canadian, Irish and UK lending codes. And they were part of our, they influenced us in terms of arriving at the conclusion that the code could do much more in this space. So I think it's the UK lending code, to begin with, that one was has sections in it that are much more sort of clearly directed to small business, identifying what applies to small business within that code. It directly addresses the issue of financial difficulty for small businesses. The other two codes are directed only at small businesses, and so they're apply for lending for small businesses. The Canadian code's very short and requires each bank to come up with its own code based on the model. The Irish code is much more extensive. Its main focus is on financial difficulty and how a business could be dealt with when it's under financial difficulty. So they spoke much more directly to a small business customer, and so we drew some comfort that our recommendations were had been applied in other areas, and we copied language and such like from it.
And having had the chance, although as it turns out not a very long chance, to review the most recent version of the code being considered by ASIC, do you have a view as to the extent to which it reflects the recommendations you made but also achieves the objects that you understood it was designed to achieve?
Look, overall, I think it's a big step forward. It's a mix of things from my point of view. Some excellent, some very good, and some where I'm a little disappointed about it. But I think overall, it's a big step forward in terms of how it's framed, its accessibility and language, and the substantive protections that are proposed under it. I think you'd have to concede that it was a substantial step forward.
Commissioner, I have no further questions for this
Thank you,
witness.
Mr Hodge. Does any party with leave to appear seek leave to cross-examine Mr Khoury? No? Very well, thank you very much, Mr Khoury, for your evidence. You may step down, you're excused. Now, we have a video link at 2, do we,
Commissioner, so if
Mr
we could
Hodge?
adjourn until then.
2 o'clock.
Thank you.